The reason that a criminal defendant must first raise his claims in state court through the state court of appeal, state highest court, before presenting them to the federal habeas corpus court, the reason he must do that is because the federal court gives respect to the state courts and the federal and the state government. The federal court says, I respect your system, and I respect that you're supposed to uphold the laws of the United States Constitution too. So we're going to give you a chance, petitioner, prisoner. You have to give them a chance first to look at these claims and to correct these errors if they're errors. And we're not going to even look at the claims unless you've given them a chance to correct them first, because it's their court, it's their case. We're going to give them a chance to correct it first. If they don't, then we'll look at it. And even more than that, that's the exhaustion requirement. So that's codified in 28 USC 2254 B and C. There's also what Congress passed in 1996 as part of the Anti-Terrorism and Effective Death Penalty Act, otherwise known as AEDPA, AEDPA. Congress said, well, we think, this was the Republican Congress of 1996, said, we think that too many federal courts have been letting out too many prisoners, and they have not been respecting the state courts' decisions. The state courts are separate sovereignties. They are their own governments. They are equal to the federal government. The federal government technically is not above the state governments, although in practice it seems that way in a lot of ways, because a federal court can release a prisoner, even if the state courts have said that the prisoner's rights have not been violated. The federal court can disagree and can order the warden to release him. And one of the reasons they orders the warden to release him instead of the state court is because they are co-equal courts. The federal court can't order the state court to do anything. But what the federal court can do is order the warden to do something. And the warden has to obey the federal court. So the federal courts give deference to the state courts. And in the 1996 U.S. Congress passed that AEDPA law, and what it says is not only do you have to allow what the federal courts had already said, the U.S. Supreme Court had already said, you have to do exhaustion, you have to exhaust your state remedies, but federal courts, you can't even grant these prisoners relief unless the state court's ruling on that federal constitutional claim is unreasonable. It has to be so wrong that it's unreasonable, like only a lunatic or somebody who wasn't doing their homework or somebody who was drinking while they're on the bench or somebody who basically was being unreasonable. Like most people are reasonable. Most people can disagree on legal issues. They can say, well, I can see how you could think that. I disagree with that. I would see it this way. If the federal court looks at a constitutional issue and looks at how a state court ruled on a constitutional issue and says that, well, I would disagree with that, but I can see how a reasonable person could come to that conclusion that this defendant's rights were not violated, this prisoner's rights were not violated. If I could see how a reasonable person could believe that, then I, as a federal judge, cannot grant relief, even though I would have seen it a different way. So that's what the U.S. Congress did. They said, federal court, you can't just disregard their decision. You have to look at their decision, and only if it's unreasonable. And not only unreasonable, but an unreasonable application of clearly established United States Supreme Court precedent. Because state courts, because they're co-equal to federal courts, they don't have to obey the federal court's decisions. So if a federal court says, well, we think on a due process claim, if the prosecutor says A, B, and C, that is a due process violation. If it tells the jury A, B, and C, that's a due process violation. State court disagrees with that and says, well, I think only if he says A and B is a due process violation, or he has to say A, B, C, and D. And the federal court will say, well, I would grant relief on that claim because he said A, B, and C. The state court said, I'm not going to grant relief because he didn't say D. And they can disagree, and one of them doesn't control over the other in the way the law is. And so this, but if the U.S. Supreme Court says that is the federal law, then the state courts have to obey that. But if the federal district court and the federal court of appeals say that, the state courts don't have to obey that. They can make up their own mind. So what Congress said in 1996 is only if the state court's ruling was an unreasonable application of the United States Supreme Court's decisions, clearly established Supreme Court precedent. It can't be questionable. It can't be like, well, they kind of hinted at it here. It has to be clearly established Supreme Court precedent. Only if it's an unreasonable application of clearly established Supreme Court precedent can you, federal judge, grant relief to this petitioner. So, in the legal sense, that makes it very hard to win in the federal habeas cases because most judges are pretty reasonable, even if you disagree with them. They're pretty reasonable. They can come up with a reason for just about anything because they're lawyers, and most lawyers can come up with a reason for just about anything, so by definition, they're reasonable. And it's hard to show that they're not. So, and that was the object of the Congress in 1996 to make it difficult for prisoners to receive relief. And it was all premised on the principle of respect for the state courts, because the Republicans were all about respect for the state courts, states, state sovereignty. That's their justification for abortion restrictions. The states should decide. And that's their justification for restricting the enforcement of criminal defense constitutional rights against states. So, in other words, it's their justification for justifying states, the violation by states of criminal defendants' rights. And I don't know if I answered any questions there, but hopefully that was at least a little enlightening.